Welcome to Ask the Attorney, brought to you by Stephen Kelly Law.
Well, hi everyone. Thanks for joining us tonight. I'm Renee Charles. I'm your host of Ask the Attorney. And with me today, I'm joined by Stephen Kelly. You are a workers' compensation and personal injury attorney. You represent both clients, the employees, and the employers all across the state of Illinois. So welcome.
Thank you very much.
Glad to be back. It's been a while since we've been on.
Been some scary times.
Yeah, and the topic we have tonight is very fitting for what we're going through, but we're going to be talking about COVID-19 and workers' compensation that goes along with COVID-19 cases. We are going to take your questions, so if you want to give us a call, the phone number is 698-3742. We're ready to take your calls. You see the number there at the bottom of the screen. Give us a call and we'll be ready to answer your questions here in a little while. But I want to tell the viewers a little bit about you as our phone monitors get ready to go.
Thank you.
So you are a Peorian, born and raised.
Yes.
You graduated from St. Ambrose University and John Marshall Law. You have a practice here in Peoria that you opened in 2014.
Yes.
So you've been established and been around here for a while. And you also have a Peoria office, a Princeton office, and a brand new office in Springfield.
Springfield, January 1st, I bought an office in Springfield and have an attorney down there full time.
Okay.
He moved from Peoria down there, Matt Brewer, and been up and running since January down in Springfield, Illinois.
And he's probably had a little bit of a hiatus or a break, as most of us have, dealing with this COVID-19 pandemic.
Yeah, the commission itself, the Workers' Compensation Commission, has been slowed down. Mm-hmm. We have not had live face-to-face contact with attorneys or a judge since March 15th. In fact, my first live trial with people are going to happen on Tuesday. We've been doing everything by webinar and been doing everything by telephone conference, just like everybody else has had to adjust during these scary times.
And now you're gearing up and getting ready to get back. And we want to talk about COVID-19, workers' compensation, both from the employer side and the employee side. But I want to start off with that workers' commission that you just mentioned. They actually proposed an order regarding workers' compensation and COVID-19. Explain that first, and then we're going to go into what happened to it.
So we were all sheltered in by the governor. We were sheltered in and we were told to stay home. But there's some workers out there that couldn't stay home. You had the firemen, you had the policemen, and you had other workers, grocery store workers, who had to be out there. So what the commission did is they acted and entered an order in themselves. Unilaterally, the commission said, we're going to enact an order saying that if you are out there and you're an essential worker or a first responder, if you get the virus, if you get COVID-19, we are going to make it presumed it's work-related. So as you start a race,
automatically a workers' comp claim.
Not automatically, but you're down the road and it's going to be presumed. You go to trial, it's up to the employer to prove it's not. Okay. Usually in cases when you present a case, you have the burden. If you're injured or you have the burden to show it's work-related. What this order did was, this order said, you know what, we're flipping the script. It is going to be presumed work-related, and what, employer, you come in and you prove it's not. And they did that, because they were worried about the people on the streets with a virus that's not detectable, with a virus that we couldn't see, but we knew it was contagious. Right. So they enacted this order, but a couple associations in the state of Illinois didn't agree with it, and in about mid-April of 2020, the Retail Association and the Manufacturer Association filed a temporary restraining order, a lawsuit against the commission and said, you can't do this. You've exceeded your authority by entering this order because you're just an administrative branch that handles work comp claims.
So they didn't have the right, or they didn't have the legal ability to do that.
The legal standing, legal authority, that was not within their province. That's exactly what the Retail Association and the Manufacturer Association stated. Well, they filed it, and there was a hearing set in Springfield, and I believe it was towards the end of April, beginning of May when that hearing was set. Right before they went in front of the judge, the commission repealed that order. Okay. I think acknowledging they didn't have that authority, knew they were going to lose. And so for a couple weeks, 3 weeks, that order was no longer on the table, and it was just as it was before. You want to file a comp case, a work comp case, you got to prove it.
But that's about to change, possibly.
Possibly.
Because now the Illinois state legislature is looking into this, and you said they have proposed a bill. It's passed both the House and the Senate, and it's now sitting on the governor's desk, that would essentially say you are presumed to have contracted this through your essential work.
So the proper branch of government, the legislature, stepped in and said, okay, if you're going to handle it this way, we are going to pass a law that says if you're a first responder, if you're an essential employee, if you're a med tech or EMT, if you're one of those people and you contract this virus, it's going to be presumed it's work-related. So the legislature stepped in, the House, the Senate, recognizing the exposure some of these people had out there during these scary times, and basically what they said is we are going to presume it is, and it's on the governor's desk as we sit here.
So we said first responders, and we said essential workers, but I know a lot of people are wondering what's the essential worker, because things have changed so much that when you first thought of an essential worker, it was police, it was fire, it was EMT, it was hospital, doctor. But essential workers is a little more broad than that, given the situation we're in.
Well, we had to eat. We had food chains. We had grocery stores. So the grocery store workers, there were people coming into the stores and being exposed to different types of people. They fall within this category. You had the retail stores such as the Walmart and Lowe's. I mean, those were individuals being exposed potentially to a customer coming in with the virus, and so they also fall within that branch. We had to survive, and people had to go to work. The essential employees as classified. So if they contracted this virus, it would be presumed under this new law to be work-related.
So what do you expect next? I mean, you said this is on the governor's desk. Sure, there are a few on his desk. So what do you expect is going to happen next? And potentially, how soon do you think we might hear something on this?
Well, I presume it's on the governor's desk that that's going to be probably signed by him hopefully in the next 2 weeks. Okay. So then it'll be in place. What do we expect next with a lot of attorneys? Probably a lot of litigation. We have a funny way of delaying.
He says that with a smile on his face.
We have a funny way of delaying things. However, let's hope in a situation if you're an employee who contracts this virus that we're talking about 14 days of being off work. Let's hope we're talking about you recover and there's not much of medical expenses. We can work through the process and get it through the commission hopefully by the time you're back to work and deal with the two issues that we're dealing with. But it's going to create some litigation.
Sure.
Certain employers, I believe, we're going to stand up and say, we're not going to accept this presumption, and you got to prove it. And as we go on in this section, this session tonight, we'll talk about what the employer can do to rebut this presumption and fight against this presumption that it's work-related.
And we also want to remind people, you said early at the beginning of the show, the commission, the Workers' Commission, was also shut down for a time. So all of those claims that had been in there that you would have gone to court over have been delayed.
Let's forget about the virus. We have multiple claims in our office, over 500 to 1,000 cases that were already there. And some of these issues in these cases deal with people's ability to pay their bills, not being paid, ability to get their medical bills paid and get a paycheck. Those all of a sudden got put on a slow pace. Clients were calling in saying, hey, guess what? We need to get this working, and we can only move if the courts are open.
Sure.
Employers the same way. It's been very active with my clients to say, okay, we've got this virus. How do we protect ourselves in this situation? How do we protect our employees? Right. That was important to a lot of my clients is not only do we protect our patients, our clients, but also our customers.
Absolutely. Well, when we come back in the next segment, we're going to talk a little bit more about the benefits that people could receive, what burden of proof means, and I think one question that I'm looking forward to hearing is, what if I'm quarantined because someone else had it in my place of business? What do I do then? So we're going to take a quick break, and when we do come back, we'll continue to take your calls and your questions. We're going to tackle those next issues. So stick around. We'll be back in just a moment. Well, welcome back, everyone. You're watching Ask the Attorney. I'm Renee Charles, your host, along with attorney Stephen Kelly. We're talking about COVID-19 and workers' compensation that goes along with it. And the timing of this couldn't be more perfect. Feel free to give us a call. We're going to take your questions. The phone number is 698-3742. Again, that's 698-3742. We're going to put Stephen on the hot spot and have him answer your questions live here. But what I want to get to before we get to those questions is, what kind of benefits could someone be expecting if they are indeed infected with COVID-19 and it is workers' comp related?
The most important benefit is being off work and not receiving a paycheck, so off work benefits. That's the most important benefit. The second most important benefit is your medical bills. If this is a work-related condition and you're incurring medical bills, hospitalization, those are things as an individual you have to pay. So that is certainly something that you have to be concerned about. The third benefit we're talking about is permanent benefit, permanent disability. If this disease and this sickness you get from work causes a permanent illness or permanent injury, you are entitled to a settlement or an award by an arbitrator for that disability or that whatever residuals from that disease.
And we also had on the that last graphic there, burden of proof. You mentioned that earlier. With this new legislation that we're waiting on, the burden of proof has to be proven by the employer, not the employee, which is flipping the script, as you said earlier, from what it used to be.
Right. So if there's no presumption, then obviously the person presenting the claim, they have the responsibility of proving their case, every element of the case. With this presumption, it is now switched to the employer to prove it's not work-related. And in doing that, employers have certain rights. They do have rights under this new law potentially, and they have rights under the work comp system. And those three things they can present is that if a person's been home quarantined for 14 days, then develops after that, while not at work, COVID-19, they beat that presumption. And everybody's back at the starting gates again. If the employer can show they've been following the requirements of the state in protecting the employees, face guards, wiping everything down, doing everything they can as an employer to protect them and their customers, they can beat that presumption.
Okay.
Then finally, if a family member or a relative of that the person who's exposed gets it, it may be presumed it's not work-related. You could have got it at home. So that also beats the presumptions. Those are the three things I see in the new law that the employers can use to defend these cases and beat that presumption.
So just because, when this new law goes into effect, just because you're considered an essential employee, you still have to prove something,
Yep.
But it's a little bit more on the employer this time, during this particular pandemic at this time.
Absolutely. First of all, obviously, you have to prove that you either had the virus or that you were quarantined with the suspicion of the virus.
Okay.
And a diagnosis of it. I mean, you have to prove you had that diagnosis, and then you can start processing the claim. And if you fall within those categories of the new law, it's presumed to be work-related.
Well, here's one question that falls right in line with what we're talking about right now. We had a caller who said, I worked at a vet clinic and was exposed by a client. The health department identified her and she had to quarantine. Her question is, should the employer pay her? Because right now she has to use her personal time off.
I think that's what's happening with a lot of employers in the state of Illinois. This is so new. I mean, you have a new diagnosis and a new disease, and I think these employers are not sure how to handle it. Sounds like under this new law that this individual who called in is an essential employee, has it from a customer. I think she can identify who had it, and therefore it could be presumed it's work-related. She has the right to ask the employer to pay for her bills and her off-work time. Now, that doesn't mean they're going to do it. She may have to consult an attorney to get it done, but under the circumstances that that question is posed, and it's a good question, I think that she's ahead in the race, and there's a good chance she can put more pressure on the employer to acknowledge it's work-related.
And that's exactly what we're talking about with this new legislation that's being passed already in the House and the Senate, is that she was an essential employee, she was supposed to be there, and she wasn't doing anything out on her own in her personal time to be infected with it.
Absolutely. If there's no family member that has it and she knows no one that has it, and then she knows a client or customer came in and she's working, she's required to be there, and she gets it, common sense says that she contracted it through work.
Right. Here's one from Arthur. Can your off-work benefits be stopped during a crisis?
Well, that's a great question, and I think he's talking about if I'm off work for another reason, I got a work comp injury.
Okay.
I'm assuming that's his question. If not, he can call me at the office. I could talk to him. But if he's off work for another injury, and this comes forward, I've had a couple cases this way, and all of a sudden, an employee doesn't feel comfortable going to work because of the COVID. Say you got COPD, chronic pulmonary disease.
Right.
And you don't want to go to work, and the employer's saying, you got to come to work. We're a grocery store, you got to come to work. You can opt not to go to work because you're concerned about yourself, concerned about the exposure.
You're at risk. You're at higher risk than the
But that doesn't mean they're going to continue your benefits. Okay. What they need to do, first of all, is talk to their doctor whether or not their doctor acknowledges they have this condition. And if a doctor writes a note saying, you know what, it's not safe for you to go, you may be, it's life-threatening for some of these people who have underlying conditions.
Sure.
They're going to stay home, and it's up to their attorney, if you have one, or you can consult with one, to push for you to get your off-work benefits. So some benefits may be suspended, but if you get a doctor saying it's reasonable for you not to go because you have a pre-existing condition, then they should start back up.
And here's another one. Can I be quarantined without a positive test? So if I have some symptoms, actually I guess this could be twofold. If I have some symptoms but I have not been positively tested, but my employer wants me to quarantine because most of us are checking our temperature regularly or should be, so self-monitoring, and I report that I have some symptoms, can they force me to quarantine without a positive test?
In my experience in this short world of COVID, the last 60 days.
Which feels like forever.
Right, there has to be something, I think, triggering the suspicion of symptoms, fever, not feeling well. If you report that to the employer, it is prudent to the employer to say, come in, let's take your temperature, let's see if you have a fever, or stay home. Under those circumstances, they don't have to pay you your work comp because we have to fall through that test, that litmus test. Is it work-related? Do you have someone at home who gave it to you? Do you not have someone at home?
Is it a positive test?
Is it a positive test? Now, that question is a great question because there are first responders out there, firemen and police officers who, let's say a fellow officer tests positive, but you're on the same shift or he's your partner or she's your partner. You then have to quarantine. If you have someone who works with you who tests positive, you've been exposed to that, you quarantine, you may have no symptoms. Under those circumstances, I think you can make the argument that, hey, this is related to work.
Right.
You're telling me not to come in and someone at work was exposed. You have an argument that the work comp benefits should be paid to that time period.
So what about the employer? We talk about the employee a lot. Obviously, this is the workers' compensation. But what about the employer? What do they need to know and what do they need to do in the context of what we've been talking about?
Right. Well, most employers that I represent, hospitals, they're doing the best they can to protect everyone. And in some hospital and nursing home situations, there's more safety measures there than not in the general public.
Right.
So we've had other conditions or other viruses and other things such as MRSA that's been out there for a while. And there is a protocol within the employers to say, we're going to do these steps to protect people. I think that the healthcare professionals have been ahead of the game because they've had to deal with this. The employers, the retail, they've not had to deal with this. And maybe a little bit slower in trying to figure out what the right thing is. As you walk into a grocery store, maybe in early March or mid-March, early April, they didn't have the protective guard. They weren't requiring the masks because we were discovering through, as this thing progressed.
We're evolving and everything
how to respond.
Is changing.
So the employers need to do everything they need, everything that they learn as we go through, everything they learn as the studies go through, to put those things in place to protect their employees, and they're doing that. And certainly, if you have an employee who has a family member, two family members who has COVID, and you have no other employee who has it, to me it smells like it's not work-related. And it's going to be very difficult for that person to establish it's related solely to that work activity.
And before we go to break, I want to hit one more question. How do I, the burden of proof, how do I prove that I have it? Do I have to have, obviously, a test that shows it? Is there a specific checklist of what I need to do for that burden of proof?
That's a great question. No specific checklist because we really haven't gone through this process yet. The first two things is you've been diagnosed or at least have a positive test. Those are going to, if you have that, then you can start the game. And then the investigation in your mind is, where could I have gotten this at? And you do this self laundry list. I don't know anybody who has it. I haven't been out. I've been following the orders. But at work, I know a couple customers that come in or clients come in, they have it. You go through that laundry list, and if you can make a connection to your work, then I would say you have a potential case. And if you fall within the classification of these employees under the new law, then you have a presumption it's work-related. So that will work in your benefit.
All right, we're going to take a quick break. We'll be right back with more questions. Welcome back, everyone. You're watching Ask the Attorney. I'm Renee Charles, along with Stephen Kelly, talking COVID-19 workers' compensation. And let's get to the first responders and public employees. There is something that's a little more special designated to police and firefighters.
Yes.
Called PEDA, P-E-D-A. What does that mean?
Public Employee Disability Act. Okay. And basically, there's going to be a time frame here where employers aren't going to accept this, and there's going to be a time frame where you're an injured person or exposed person that you're not getting your benefits right away, and you're looking for avenues or options to get benefits or get your pay. The first responders, firefighters, and policemen have the PEDA statute, and it falls outside of work comp and it falls outside other statutes, but allows them to collect full salary while they're off for this virus and allows them to collect their full salary while they're off and not be forced to use their sick time and personal time. I'm getting a lot of phone calls, a lot of concerns. Not a lot of people that were exposed, but when this was coming down, they had to go to work.
They wanted to know.
They had to go to work, and they were concerned.
Sure.
What do I do? I don't want to be forced to take my personal sick time. I don't want to be forced to take time I earned throughout my employment. So that's an option for them to file for as PETA as a process to get some benefits.
So that would save some of their sick days. Yep. Would help with their health insurance.
Yes.
And then again, it's that bridge between workers' compensation, but we're only talking about first responders in this particular.
In my life, you used a great word, bridging. Mm-hmm. People come to me because that bridge is not there. They're trying to pay their bills. They're trying to get the off-work benefits, and that's what the calls are about. So to answer your question, relate to you're not a first responder, the work comp system is what you have. Mm-hmm. Some employees have short-term disability, depending on the employer. Bigger employers in town have that. But some don't. And if you don't, then you need to consult an attorney because there could be a 14-day period in a quarantine. You're not getting any money, and they're not going to accept it.
So what about other employees in the state, public employees? We've already talked about private sector employees. What about other public employees?
So if we're talking about restaurant workers, we're talking about other employees who don't fall in this category, they are not given this presumption that they don't qualify as an essential worker. And if they feel this is a work-related condition, they're going to have to go through the process. They're going to have to file the claim without that presumption. And the benefits they're seeking are the work comp, off-work benefits, the medical expenses, and potentially disability benefits. But they're going to have to prove their case without the wind behind their back that the presumption gives you. So
what would your advice be to someone who says, I think I've been in contact with someone who had it or has it? If you think you've been contacted and you don't have symptoms, if you're available to get a test, go get a test. That's why I would tell them the first for their safety. If you know someone has it that's an employee and you're concerned and you start having symptoms, go to your doctor and then self-quarantine. Follow your doctor's orders. But if the doctor believes it's work-related or at least there's an exposure there, have him write it in his note or comment in his note, so you can have that to give to your employer. This is about being safe for yourself first, and then worry about the legal matters later. But you need to establish it's work-related at some point. So then, what would be your advice to an employer who comes in with the same thing, saying, "I want to make sure that I'm taking care of my employees"? What should they do? Most of my employers are sophisticated, so I am relieved and I'm confident they've done everything they could to this point to protect their employees. Obviously, if we have a facility or an employer who has 56 breakouts, it's not good. You have it in your facility. Your employees are getting it because of something in your facility, right? If it's one COVID case out of 1,000 employees, then the employer has a right to investigate that. But most of my employers have been doing what they've been required to do to protect their employees. And they've been standing up, and if they think it's work-related, they've been accepting it. And those are good employers. In times like this, you need good employers, and most employers are good employers. And we talked a little bit before we started about those who are required to show up to work and those who are working remotely. And there is a bit of a difference there in how those cases are handled. Absolutely. If you've been home remotely for the last 45 days and you now have COVID, there's going to be a serious question as whether or not that's related to work whatsoever or any exposure at work. It seems like it occurred at home. If you're a traveling employee, traveling nurse, then there's more questions. You're out in the public, you're doing things. But I think as time goes, employers and employees are adapting to this new Zoom world, adapting to the world of webinars, and I think that it's going to be safer for us. We're all walking down a new technology path. I've been very fortunate. My office has been paperless for the last 2-3 years. My attorney's been working remotely, and my staff's been working remotely until the last 2 weeks. So hopefully this is everybody can learn from this and take the cue of this is what we need to do next to protect everybody. Well, believe it or not, we're already out of time. Fast. So I know this is fast, and this is a topic that I think is on everyone's mind right now. So give us your phone number if people have questions and want to contact you. They can contact me at 309-453-8639. That's my cell phone number. All right, located on Knoxville and Peoria, also in Princeton and in Springfield. Attorney Stephen Kelly, thank you so much for joining us today. And really explaining things a little bit more so that we can all stay safe and healthy.
Thank you so much.
You bet. Thanks for joining us tonight and watching Ask the Attorney. We'll see you next time.
Be
Good
safe.
night.